will start as soon as you introduce yourself to the court. Is there any preliminary matters or announcements that need to be made? Seeing none, you will call the first case, please.
Adrian Claybrooks versus Christian Manuel et al.
Good afternoon. If it may please the court, my name is Damon Duggar with the law offices of Louvel L. Glanton and the Nashville Bar. I represent the appellant Adrian Claybrooks. This appeal asks whether a uninsured motorist plaintiff who timely filed suit, properly served his uninsured motorist carrier, and repeatedly attempted service at the tortfeasor's last known address should lose his day in court because the trial court demanded a perpetual search beyond what is contemplated in the uninsured motorist statute.
Would you like to reserve any time for rebuttal?
Pardon me, Your Honor. Yes, 5 minutes, please.
5 minutes.
Thank you. Respectfully, the answer is no. Tennessee law, both the uninsured motorist statute and this court's precedent, strike a balance between fairness and efficiency. On the one hand, the uninsured motorist carrier's right to subrogation. On the other, the plaintiff's right to an efficient process by which to be made whole. Plaintiffs must make timely attempts at service, but once those attempts fail, the insurer must step in and defend. The trial court's contrary dismissal in this case rewrites the statute, misapplies precedent, and effectively holds an uninsured motorist plaintiff hostage to an indefinite insurance reissuance requirement.
All the service attempts here were by mail, is that correct?
Yes, Your Honor.
Okay. In reading the UM statute, I'm struck by the use of the phrase "not to be found in my county" under subpart D. Does that imply a particular type of service must be attempted under if you're going to meet that statute's requirements?
Your Honor, we would submit that no, it does not. Let me see here.
Well, what would be words to that effect in a mailing context?
In a mailing context, well, for example, one of the responses submitted was not picked up. And in this case, for example, one of the attempts at service to Murfreesboro Motors was initially came back unable to deliver or address undeliverable, and then the next attempt went right through the alias summons. So specifically, the driver in this case, Manuel, came back, did not pick up. It said service undelivered, address undeliverable, and then did not pick up, no forwarding address. And it's our position that the statute requires that an attempt be made at the person's last known address.
And that can be by mail?
Yes, Your Honor.
We, in interpreting Rule 3, we've often talked in terms of, the court's always spoken in terms of diligence. The plaintiff has to be diligent in attempting service. And I'm wondering if diligence requires something more than service by mail, that you take another step beyond that. Once you've determined that mail is not working, that you at least try to get a sheriff out there to try to serve the warrant. Why wouldn't that be a way to look at diligence?
Your Honor, I would say that that would create a hierarchy of acceptable forms of service under the statute, and that the plaintiff was completely reasonable in relying on an acceptable form of service under the Tennessee Rules of Civil Procedure. As far as the notation on the return in Webb v. Werner, 163 Southwest 3D 716 at 720, there was an attempt at service in person that failed, and then service was attempted in Switzerland. The return came back. The court made note at the time that there was no attempt to translate what was written on the return. But in so doing, it said it is irrelevant what is written on the return. The fact is that timely service must be attempted at the uninsured motorist's last known address. And that's what happened here. And especially given that, considering we have a hit-and-run accident, the odds of a person answering the door to a sheriff's deputy are pretty slim, I would say, and that this would be the best way to get them served. As far as the statutory and procedural framework that is at issue in this case, as Justice McBrayer mentioned, Tennessee Rule of Civil Procedure 3 requires reissuance of process within 1 year if service fails. Normally, that rule controls commencement of the action, but Tennessee Code 57-7-1206D creates an exception. It provides that if process against the uninsured motorist issued to his last known address is returned not to be found in my county or words to that effect, then service on the uninsured motorist carrier is sufficient and the insurer must proceed as if the only defendant.
Counsel, what is the meaning of words to that effect? What is it? What's the effect we're talking about here in terms of the not to be found in my county? How should we understand that language?
Well, I would say that words to that effect, it's not to be found in my county, is not to be taken literally. When a sheriff's deputy here in Davidson County goes to someone's house and attempts service and they don't answer the door or aren't home, they write not to be found in my county. That does not literally mean that the person is not to be found in my county. It means that service at that particular location failed. And I would say that the comments, the notations on the returns that we received are words to that effect. These persons were not found at this particular address.
Well, I'm worried, though, about diligence, again, under Rule 3. Is it enough to fill out a summons and put any address on the summons, whether it's a good address or not, and say, okay, well, I've satisfied the UM statute, and that also satisfies Rule 3? I mean, is that really being diligent?
Absolutely not, Your Honor. And there are cases where the dismissal was rightfully upheld because there was no attempt to serve the uninsured motorist at their last known address. In this particular case, the complaint was originally filed only against the uninsured motorist carrier. This was a hit-and-run accident. The uninsured motorist carrier identified Mr. Manuel and Mr. Alvarado, provided their last known addresses, and that Mr. Claybrooks amended his complaint to name both of those uninsured motorists and attempted service at those addresses provided by the uninsured motorist carrier.
In looking through the record here, I noticed that there was a summons issued for Mr. Alvarado on September 22nd, 2021, but it doesn't appear that there was any return at all on that. Why is that?
Your Honor, I could not speak to that. We have, if you'll excuse me for just one moment. Mr. Alvarado, looks like we had a summons, forward time expired, returned to sender.
Well, the September 22nd one doesn't appear to have any return at all. I'm wondering if we're missing something from this record.
In this particular case, the trial court asked that the plaintiff file all of the return cards and summonses that were issued in making this determination, and that's what was available in the court's record.
Okay.
That was designated for this appeal.
There was an alias, or I think a pluri summons, issued January 19, 2022, and then there was this long gap of no activity in the case. What was happening there? Why wasn't there follow-up attempts in their interim, not until July 3rd of 2023?
Well, the plaintiff, at that time, if I'm not mistaken, at that time the defendant had filed their motion to dismiss.
Right, which prompted a new issuance of a summons, I'm assuming. But what happened in the interim?
In the interim, the plaintiff felt that ample attempts had been made to serve the defendant within the year. Quickly, the court's reliance on the Winters case in dismissal imposes a requirement of due diligence that is not contemplated in the statute. Statute requires that the plaintiff issue summons to the last known address of the uninsured motorist, and the notation that is on the return is irrelevant. What matters is that summons was issued timely to the defendant's last known address. That's what's done in this case. That's what's done repeatedly. That is what's documented in this case. And to hold the plaintiff to a perpetual standard of reissuing the summons would hold them hostage and provide a trap door through which uninsured motorist carriers could escape. Thank you, Your Honor.
Good afternoon, Your Honors. My name is Jamie Johnson. I am the attorney for the Applee Direct Insurance Company. I'll just dive right in. So Rule 3, which is applicable here, is obviously very clear, and the court I know is very familiar with that in it requiring that an individual who wants to continue and not face a problem with the statute of limitation keeps issuing a new summons on the anniversary if they issued one after they filed suit 12 months after the fact. There's nothing unclear about that statute. Likewise, about that rule of civil procedure. Likewise, the statute 56.7.1206 is equally clear, Part D, about what you have to do. And counsel stood up here a few minutes ago and said, you know, it's about striking a balance. And I would agree with that, because when you look at this statute, it is very detailed. What you have to do is you not only have to it says in the event that service of process against the uninsured motorist, it has to be issued to the motorist's last known address and is returned by the sheriff or other process server marked not to be found in my county, or words to that effect. And I'd like to draw Your Honor's attention to the statute line that says is returned by the sheriff or process server marked, not and then marked, meaning that if you read the plain language of this statute, it would indicate that it is the sheriff or the private process server who is to mark that it was not to be found in my county, not an attorney who tries to fix the situation later, which is what we have here.
Well, but Tennessee allows attorneys to serve process, do they not?
Yes, absolutely, Your Honor, they do.
So why wouldn't an attorney fall under the definition of another process server?
Well, they were trying to serve them here by certified mail. So had they been the ones to try to serve it and they were going out and trying to do it, then I think they could do that. But they were trying to serve them by certified mail.
And so your interpretation of the statute then is it excludes service by mail?
I don't think it excludes it. I think Rule 4, here's the crux of that. Rule 4 allows them to use certified mail under Rule 3. In other words, if you're just trying to continue keeping someone in a lawsuit, one of the many ways you can serve somebody under the Tennessee Rules of Civil Procedure is through certified mail. The problem is it's not enough, or at least if you're going to do it, if that's the way you want to hang your hat on trying to get the benefit of the statute, then it's going to make it an awful lot harder, which is what you brought up earlier in your question to counsel. Because at this point, you're left relying on the return of the U.S. Postal Service. And they may not come back with language that not only meets the statute, but they might not actually do what it takes to serve somebody. Meaning they may just knock on the door and put a sticker on there, and then if the person is not home, it's up to them to go to the Postal Service to sign for a package. That's not what a sheriff or a private process server or an attorney who wants to act as a private process server would do it.
is it a fair summary of your argument here on appeal that you're not faulting, it seems like to me there's two components of this. The first component is that you've got to get that alias summons out at the last known address.
Correct,
And the second component being the return.
correct.
You're not arguing that they didn't comply with the first component. They got a summons at the last known address. It's only the return component that you're faulting here, and that's because of the manner of service employed.
It's not only the manner of service, yes, correct. And it's not only the manner of service employed, because I think that there's big questions about whether or not that meets their due diligence burden. But it's also the fact that when the return came back, it is not words similar thereto, which, to answer your question, is words that mean the exact same thing, that mean not to be found in the county. So the plain reading of this statute in balancing between the rights of the insured and the rights of the insurer is that the reason it's not a mere formality is because the insurance carrier has a right to subrogate. If they are now going to be put in the hot seat because someone has complied, and they haven't in this case, but if an individual has complied with the statute, and it's clear that it's got to be both, it's not just about issuing to the last known address, it's about getting that verbiage back. And they cite the Lady case, which I think is very interesting in their reply, because the Lady case says you are to follow it by the letter of the law. It doesn't give you any wiggle room. He's trying to say, well, that isn't really what it means. It doesn't really mean that they're not to be found in the county. I would argue that what it means is if the defendants, if you send it to their last known address, and the defendants are not in that county to be found because they went to the last place that they would have known them to be in that county, then and only then does the insured have the right to now go, okay, now I've paid for insurance, so now I have the right to be able, instead of just sitting here waiting on someday to find this person, now I get the benefit of what I paid for, and I'm going directly against my company.
It sounds like you're faulting the plaintiff here, though, because they get a little more information by service by mail. A sheriff is not going to tell you, deputy, that the forwarding order is expired, for example.
Well-
Which seemed to really concern the trial judge here, that because the return came back, forwarding order expired, there could have been more done to serve this unknown defendant.
That's exactly right, and I think that is the problem. I mean, first of all, it does matter what's on there. He tried to say that it doesn't a while ago, and he cited the Webb case. And in the Webb case, this was an individual that was sued who the last known address was Switzerland. And the plaintiff attorney went ahead and issued a summons to Switzerland, but instead of going ahead and following through with service, he decided to take that Switzerland summons and then try to serve him locally, and then sat on it, because he said, I heard he worked in this county somewhere, which was in Tennessee, and then he sat on it for months, and then returned it when he remembered, oh, I didn't ever return that, and put not to be found in my county. So he wrote that. And then they waited over a year before they issued the second summons. So when counsel stood here and said that this particular court in Webb said that it doesn't really matter what's on the summons, they were referring to the second summons. And the reason why is because the court's holding was actually found on what did these people do between the issuance of the first summons and the issuance of the second summons, and they found there wasn't due diligence.
Counsel, why is undeliverable not a word to that effect? When it comes back as undeliverable, why doesn't that one fall in the category?
Well, first of all, the only time it came back, it didn't come back undeliverable, just so you know, Your Honor. I want you to notice that if you look, and I can talk about any one of these, I've got them marked. I know these like the back of my hand. There were 7 summons that were issued for these 3 different subject defendants, okay? And only 2 of them came back with green cards, and yet they were all issued by certified mail. So I think that's telling that why do we only have 2 of these green cards that have come back? And the 2 that came back said that they were blank. What they get back from the Postal Service is unclaimed, not deliverable as addressed, unsigned. Now let's talk about not deliverable as addressed, okay? Not deliverable as addressed could mean that there wasn't an apartment number on there. It could mean that there wasn't a suite number on there. It could mean that it was just illegible and they couldn't read it. It doesn't mean that the person does not reside there. Counsel is the one who came up with this phrase, service failed, address undeliverable. Counsel came up with that. If you look at these returns, it's actually the attorney that's signing these, and he is marking out on many of them when he even got the return. He's just marking through that language and writing on there, service failed, address undeliverable. He did that 5 different times. And if you could say, well, it doesn't give us any reason for why it's undeliverable, so I would certainly argue that because of the balancing test, they don't get the benefit of 56.7, 1206D, because it only says, now this is the attorney's words, address undeliverable. It doesn't say why that it's undeliverable. But let's just say that that was enough. We know by their own action that it wasn't, because if you look at the return to the only defendant who was rightfully served in this, which is Tennessee Motors, they tried to serve Tennessee Motors the exact same way by certified mail, and it came back with their writing on it that said that they're the plaintiff attorney, service failed, address undeliverable. That was in December of 21. The very next day, they reissued the same summons to the same address, and it was signed for. This is a business that's been in place forever. There is no, to this day, we don't know why that first one got returned and the lawyer wrote on their address undeliverable. But obviously, we know now that that does not mean not to be found, because they went back within 24 hours and got a warm body who had been there all along, because the business obviously didn't move in overnight, and signed that return. And that was important to the lower court, and it's important in this case for your consideration, because that shows why that verbiage does not mean what the statute intended for it to mean. And I would also like to draw your attention, since they've put this under the microscope, since it's the attorneys that have decided to do this by certified mail, and they want you to believe that they've used their due diligence, I'd like to draw your attention to the other things that should be looked at, which is there are at least 2 of these returns that came back, and I'm going to tell you specifically which ones I'm looking at. One of them is a return that is signed. It was to Wilmer Alvarado individually. This is a return where they say that the attorney certifies on January 19th of 2022 that he sent it out by certified mail, and that it came back, service failed, on January 25th, just 6 days later of 2022. And yet what they filed in support of that contention is a letter that is dated January 25th of 2022 that they allege was sent. So how can you have a letter dated January 25th, 2022 to Mr. Alvarado that says, please find enclosed a summons and a complaint, and you've alleged to the court that that's the day that it came back unserved? That's not the only time you'll see that. Also, if you look at that envelope on that, they've certified, the attorney has certified, even with a notary on that particular return, that they sent that out on January 19th of 2022. But if you look at the envelope they filed to support that, it actually shows it wasn't mailed out until January 22nd of 2022. And that's the one that came back that they're saying is attached to this particular summons, and that's not the only one. If you look at the return for Christian Manuel, the one that has no address that you all asked about before, for the first time, they're alleging in their brief that that actually has an envelope, even though there was no address on the summons itself, but that they actually tried to send it to 208 Vista Court. On that return, it says that they sent it out on August 29th of 21, and yet the envelope that they've used to try to convince you all that in fact they did send it out to an actual address shows that it wasn't mailed out until September 13th of 21. That's what's stamped on the actual envelope. And then we have another example of a letter. This one is to Christian Manuel. This one, the attorney certifies on January 19th of 2022 that they sent it out to him. And when you look at what they said was in that envelope on January 25th, the letter says it's dated January 25th. So how can you have a letter that's dated after it was mailed per the return, and the return itself says that it was mailed on January 22nd? So there are all kinds of questions that are raised with the sloppiness, quite frankly. I'll just have to use that word, with the way that this was handled, with them going back and forth with this certified mail. And I think what's really important here is that, you know, when the situation happened with Tennessee Motors, that was in December of 21. They didn't fail to comply with Rule 3 until the clock stopped ticking January of 23. So they were on notice. I think due diligence was requiring somebody to be paying attention at this point to go, look, this notion of things coming back saying, you know, and we're writing on their address undeliverable, like you said, is not cutting it. And now we know it's not cutting it because now we tried to serve a business that one day we wrote address undeliverable and 24 hours later we got them served. So they were on notice for more than 2 years that this certified mail situation was not working. Now they would say, you know, it's a right that we have. Well, it's a right they have under Rule 3, and they could have kept that up in perpetuity. And I think that's what Rule 3 would require. But they want to skip over that. And by the way, the first time that the notion that they were wanting to use the benefit of the statute, or that they thought they had met the benefit of the statute, was after we filed the motion to dismiss. And it was at that time that they started supplying all of these returns and all of these envelopes saying, you know, we believe we've met it. And at the end of the day, the case law that they hang their hat on are examples of folks who actually got the return that proved that someone was in the military. A private processor comes in and says, we're not able to serve them because somebody's in the military, they're not here. Or they actually got the literal phrase, not to be found in my county.
But the Lady case does seem to suggest that you get out of the Rule 3 business by complying with the statute, by, you know, if once they're identified, all you have to do is issue your alias summons, and then you can proceed against your carrier directly.
And that's if you fully comply, and I would agree with that. In the Lady case, they got a not to be found at the last known address, which is why that they then brought in Transamerica. So what they did was they tried to serve the individual, and it came back not to be found, and that's the reason they then brought in their carrier. And that's the difference between this case and that one.
All right, thank you.
Thank you, Your Honor.
Mr. Duggar, we'll hear from you on rebuttal.
Thank you, Your Honor. As you pointed out, the Lady Oak versus Krager case states that the suspension of the Rule 3 requirement during a subsection D proceeding is consistent with legislative intent to provide an efficient procedure. The defendant, uninsured motorist carrier, said that Rule 3 imposes upon the uninsured motorist plaintiff, if they're serving via certified mail, a perpetual duty to attempt service. And if one of those fails, sorry, out goes your case. In Davis versus Grange Mutual Casualty Group, 2017 Westlaw 4331041, that's from this court in September 28, 2017, this court clarified that a notation on a summons is not dispositive. What matters is that the summons was timely issued and attempted to be served in compliance with Rule 3's terms. The trial court, in dismissing this case, elevated form over substance, ignoring Davis and misreading Winters. And the Davis court actually relied on the Webb case, as we discussed earlier. The appellee is arguing that mailing summonses and receiving notations such as service failed or unclaimed is not due diligence. And respectfully, this is not the law. Under Fagg versus Butner, 2008 Westlaw 4876535, Tennessee Court of Appeals, November 10, 2008, this court rejected an insurer's argument that a plaintiff must endlessly issue summonses. This court recognized that multiple failed attempts at the last known address satisfied 56.7.1206D. Furthermore, it warned that requiring a never-ending duty to serve would undermine the statute's purpose. Likewise, as we discussed before, in Webb versus Warner, dismissal was upheld only because there was no evidence of an attempt to serve at the last known address. That is not the case here. Appellant did exactly as the Webb case and the Winters case requires. And moreover, the Winters case, on which the trial court relied in its dismissal, involved a plaintiff who did not attempt to serve the uninsured motorist at their last known address.
Isn't it the prudent thing, though, for a plaintiff's counsel, if they want to make sure that they come under the statute. There's a real easy way to do that, and that's to send it via the sheriff and get the not to be found in my county. I mean, that clearly ticks the box here. It strikes me that a plaintiff is playing with fire a bit by resorting to service by mail. I mean, you get these arguments as a result because you're not ticking the box, which, again, an extra fee, but it's not that exorbitant to get the sheriff to attempt service.
Yeah, yes, Your Honor, I agree. And in hindsight, that would have been the more prudent approach. However, the statute does not require, nor do the Tennessee rules of civil procedure require, that you go via the sheriff. And as respectfully, as I pointed out before, the notation on the summons is not dispositive.
So how does a plaintiff in a circumstance like this, when they have not gone that route to try to serve via the sheriff, show their diligence? What do they need to show the court that, hey, we were diligent under Rule 3?
I would say a summons, a pluri summons, and an alias summons issued to the last known addresses provided by the defendant uninsured motorist carrier, all of which are in the record. Some clerical issues aside, those were stamped and filed in accordance with the law. I believe that our efforts in this particular case, while wanting in some regards, still fulfilled the requirements of the statute and suspended the reissuance requirement under 3. I believe, according to what this court has found, that the uninsured motorist statute suspends that reissuance requirement because to do otherwise would hold a plaintiff beholden to a perpetual cycle.
Counsel, does the obligation uptick when you get responses or returns like unsigned, forward time, expire, return to sender? Does that increase the duty when that's the response, as opposed to, let's say the first one's undeliverable? If it comes back unsigned, isn't that different than an undeliverable?
Well, in this particular instance, I would say that it has to do with the vagaries of whomever fills out the card. I'm not sure that there's any particular magic words that's going to change the obligation on the serving party. The fact is that it was attempted at the last known address, and we have documentation of that. I think that there is the danger of imposing an obligation that is not found in the statute and provides a trap door for uninsured motorist carriers to escape by this could go on for years, literally years, every 6 months reissuing a subpoena. And you better not mess up one time because you will not be made whole.
Counsel, you're out of time.
Thank you, Your Honor.
Thank you. The case is submitted. If you will call the next case, please.
Raul Martinez versus David's Group LLC.